Yellow Farm, Gege, it's TGIF, and I'm here again. So I've been getting lots of queries and concerns, about the objection by INEC and the other respondents. And someone was even telling me, are you sure they will not even object to the fact that they conducted the 2023 elections? Quite funny, but they have to object because it's part of their job. And if they're going to be relying on their final written address, it simply means that they will be trying to persuade the court to attach little or no weight to the evidence as provided by the petitioners. Interesting. There are two factors of an evidence. One, the admissibility of that evidence, and two, the relevancy of that evidence. Now, an evidence might be admissible but not relevant. In this instance, simply means that that evidence may not add or may not connect to the dots of the facts in issue, and it is left for the court to determine that. Also, an evidence might be relevant but not admissible, and in this instance simply means that maybe due to one or two contraventions of the provisions of the law, that particular evidence cannot be admitted in court and marked as an exhibit for easy identification. Do you want to understand the legal implication about what happened today and the forecast for the next adjourned date? Then follow me. Let's go. Welcome back to my channel. If you're just joining me, I say welcome. And if you've been here before, you already know the love. I love you guys so much. Thank you for your comments. I keep seeing lots of interesting comments. Thank you so much. And if you have any question, you can put it in the comment section and I'm going to answer everything. Okay. So thank you. It is still Obehi and the law. And I say welcome everybody. So like I said earlier, INEC, they've been objecting to a lot of things, but you don't expect them to say, I accept, even though there are some train of thoughts like, okay, if they are objecting to their certified true copy document, is it that they are going to be bringing something different or what? Are they going to be bringing maybe a different document, or would they not say it's not their document? How will the court prove, via forensic evidence that, okay, this document is their own or it's not? Their documents, because can INEC actually speak against itself? So it's a lot. But first of all, in court today, we had the appearance of the petitioners, which was led by Dr. Uzochukwu Levi, San. And I know Peter San was actually the one who led the admission of the documents, as the presentation of the documents for admissibility by the court. And we probably had the first respondent, the second, third, and of course the fourth respondents from the other side, which is the first respondent, INEC, led by Pinero San, Dr. Kemi Pinero San, and then the second respondent was also in court. But I don't think Dr. Olanipeku San, I don't think he was around today. It was led by someone else today, and then the fourth respondent. And if you want to know, because I know a lot of persons are asking me, second and third respondent is Tinubu and Shetima. I think one lawyer representing both of them. And then the fourth respondent is APC. And of course was led by Fagbemi San. So the court was in high spirits today. But before they called, our matter, they had to deal with this APM, Alliance People Movement matter, because it was quite short that the court had seen that they were not able to obtain the Supreme Court judgment, which was supposed to be the crux of the matter for them. So there was no need delaying them in court, for our own matter, in which we can see the basket of evidence that I call it a trailer load of evidence that LP brought to court today. So we they asked them to adjourn, so they adjourned for 9th of February. I'm just giving you updates. It's not like that's not my major business, but just to give you just a quick rundown on how it went in court today, because I was in court. If you don't agree, go to court. So that was it. So they called our MAA, and then we had to, first of all, present. You notice yesterday, we presented only 15 local government for Rivers State. One of them, because the spelling was not rightly done, the court was like, no, you cannot, we can't have that because it's supposed to be Opobo Nkoro, but they gave only Opobo, and the court was like, no, we cannot have that. It's not correct. So they did not present that. But today, we had them coming in to present 6 other local governments. I know a lot of people said, there's no Obiakpo. Obiakpo is the facting issue. We had a lot of voters. Don't worry. I'm sure they are working on it. The truth is that until this case is over, they can come and present as many documents as possible, provided it is relevant to their petition. Before the court will now look into the authenticity of that evidence that has been marked as an exhibit, they can present as many documents. So don't be surprised if on Monday they still come and say, okay, going forward, because they did not only present an additional local government documentation for Rivers State, even for Niger, which is Bida local government, it was equally added to that report. So the court is, it's sort of flexible, but our eyes are tuned to the reasonable man's test at the end of the day, based on what? Evidence that has been brought before it. Remember, you shared the statement, the court is not a Father Christmas. The court can never give you what you did not ask for. The court is not God. God can give you restoration with compensation. The court, no, they do like that. The court will only give you what you have asked for, or according to what? A reasonable man's test, based on the evidence that has been brought before her. You understand now? So that's how it goes. So going forward, then they started objecting as usual, and even one of them, the APC lawyer, said, I'm going to prove to them that they have actually labored in vain. I think that was actually quite arrogant, but we move on. So I think they presented documents, 31 from Adamawa State, 31 local government from Adamawa State, and it was admitted in evidence and marked as exhibits. 18 local government for Edo State, 8 local government for Bayelsa State, 20 local governments for Lagos State. We equally had for Oyo, and yeah, people presented. I think Akwa Ibom was the last. 31 local government for Akwa Ibom State was equally presented today and admitted in court and marked as exhibits. You mark them as exhibit for easy identification. You understand? So that when they are calling it exhibit, this, you just go to the schedule that you have been given, and then you look at it, the petition schedule, and then you check, and then you see what they are talking about. Because trust me, the documents are a lot. So we need to be able to identify them appropriately and adequately so as to save the time of the court. So today, well, the thing is, all the documents that were brought in, they were opposed by the first, second, third, and fourth respondents respectively, and they were all relying on the written address. Although for the Rivers State one, which was the first, that was called, I think INEC was trying to be very funny, and they were referring to the social media, and the court told them, no, we need to focus on this. You understand? So the court had to caution him that. And then he even asked next, like, who is opposing next? And the next person came up to say, I'm opposing based on this or that. The court is not here to dilly-dally, because this is a time-constrained hearing. Now, let me tell you how this works at the end of the day. If at the end of the day, when everything is over, all arguments have been heard from both sides and all of that, if this matter, which I see if it gets to the Supreme Court will not call any witness. The Supreme Court will not admit any evidence, any additional evidence. The Supreme Court will only look at the trail or line of thoughts of the judgment that has been given by the lower court, and then come to an agreement or a conclusion that, okay, the lawyer did not, err in any way, the judge did not err. This judgment is actually in line with the laid down principles, and they will affirm validity of that judgment, or overturn and give a fresh judgment, but they will not call anybody. So this is actually the time of both parties, you understand, to give evidence, present evidence, and if the evidence is admitted, simply means the court is going to look at those documents, because they will definitely be marked as exhibits. Do you understand how it works now? So for Supreme Court, they are not going to do any additional, it's not going to take the whole day, because they will just be looking at, okay, this is what was done, what is the law? What are the principles that this judgment is supposed to be upholding? Or what are the principles that this judgment is supposed to, negate, remove from the whole process? So that's how it works. So back to the case. So after calling all of the states that they had to call, Peter Afuba had informed the court that we have done everything. We've called everybody, Peter Afuba-san. We've done everything that we're supposed to do, you know. So what is next, you know? And they were like, even Saturday, the court had equally marked that date for hearing as well. But because the other lawyers, the respondents, they were objecting that please let's move it to Monday, you know, because we have a lot. We are here from morning till evening because even PDP matter, which was supposed to come next, they will have to be in court for that. So they would need to rest. So we equally had a lot of laughters and all of that. I don't want to go into that detail because some judges were really funny. Like, for example, when they called Apapa, the judge was like, call that again. And you know where he's driving at. Lamidi Apapa, stray bullet, just go hit that baba for one corner. And so many others. So but the date was adjourned with prejudice. Now let me explain. Because when you say, oh, it was adjourned, no, that's not the full story. It was adjourned with prejudice. Because at first, Levi Uzochukwu was telling the court, that's the petitioner's lawyer, that, oh, if you adjourn this case, you know, is it not going to affect our time? You know, because if it's going to affect our time, please, let's come tomorrow. But if it will not affect our time, I'm very happy for us to move it to Monday. But the court had said, well, it's going to affect. So that's why it is with prejudice, with condition. And that condition is premised on the fact that that one day that people did not sit is part of the 3 weeks, you know, that has been taken away. So we're going to be meeting on Monday. Another new development is the fact that our case is now going to be by 2 p.m. from Monday to Friday next week. And then we'll have PDP come up 9 a.m. in the morning. So you may be expecting my videos later than usual, but all the same, it will definitely be covered. So I will say, enjoy your weekend, ask your questions, and pray for the success of your mandate. If you believe that your mandate has been stolen, you know what to do. If you have questions for me, drop them. I'm going to answer them. I might do a quick video tomorrow just to answer all of your questions. So let me know what you're thinking. Are you thinking what I'm thinking? Let's rub minds. But in the meantime, enjoy your weekend. Don't forget to follow me. Don't try it. If you love me, follow me. I have other, other handles where you can follow. Instagram, it's still obey_oris1. Facebook, obeyoris. Twitter, obeyoris. TikTok, obeyoris as well. I love you guys. Don't forget to subscribe, share this video across all of your media platform handles, and don't forget our mandates we must reclaim. Have a lovely weekend. Bye.